Good evening and welcome to Aging with Attitude. I'm Alan Levin, and our guest tonight is an old friend of Aging with Attitude, Jennefer Garrity, an elder law attorney with the firm of Garrity Gossage. Welcome, Jennefer.
Thank you, and thank you for having me.
Oh, it's our pleasure. Elder law, what exactly does this comprise?
Elder law really includes a lot of different aspects, but at Garrity Gossage, what we deal with is helping seniors and their families deal with all those issues that the aging face. It includes getting documents in place, wills, powers of attorney, living wills. It includes estate planning. It might include some Medicaid, Medicare issues. It also really includes some other things like guardianships and just pretty much anything that seniors face.
Okay, sounds interesting. Sounds like a lot of paperwork, a lot of documents involved here. Let me ask you: does an ordinary family without tons of money, or need all these things?
Well, it's important for anyone with a family to have a few certain documents in place. The will, everybody knows pretty much what a will does, but especially for families with small children, a will is extremely important because it can help the family decide or put on paper who they would want to take care of their children if something were to happen to them. But from a senior standpoint, a will allows people to do what they want to do with their assets or certain personal property. Then there's also the powers of attorney, both for health care and for financial issues. And those documents are extremely important for everyone to have in place to allow them to make a decision ahead of time as to who is going to help them make decisions if they're no longer able to do so.
I see. And
then, of course, a living will is just a fabulous tool to have in place if you know what your wishes are with regard to end-of-life care.
Well, what's the difference between a living will and a healthcare power of attorney?
A healthcare power of attorney allows an individual to name someone, an agent, who can make decisions for them when they are no longer able to do so. It actually works in connection with the living will. The living will is a declaration, and it just says, X, Y, Z, these are my wishes in certain circumstances of end-of-life care. Okay,
I got you. And I've heard something about cremation documents. What is this all about?
These are becoming more and more popular, and basically it's just a decision that's laid out ahead of time. If someone wishes to be cremated, then it spells that out and it says, these are my wishes, and then it's not up for discussion later on down the road.
It wouldn't be sufficient to just put it in your regular will, or?
You can. It's virtually the same language,
yes.
But sometimes if it's a separate document, it can, be, the wishes are spelled out there specifically without having to bring the whole will into it.
Okay.
But it certainly can be done as part of the will as well.
Okay. Once I make a will, let's say in one state, do I need to modify it if I move from state to state?
It depends. I know that's a great legal answer, right? Many states, the wills are good from state to state, so it really doesn't matter. But the big thing is you want to make sure that it does what you want it to do and that it is valid in that state. We see a lot of folks here moving from other parts of the country, coming here to Charlotte, either to be near family or to just retire to the nice community. But it's important that those wills that are coming, if you have wills from other states, that they in fact satisfy the requirements of North Carolina law.
Okay.
In addition, it's always good to have your will checked out if it's been a while, just to make sure that it still in fact does what you want it to do.
Okay, I get you. Well, that would certainly make sense. So update your will every few years, or when your situation changes or your assets change or something like that.
It's always good if you have a major life-changing event. If there's either new family members, if there's a divorce, if there's a move, if someone has died, if significant assets have changed, either gone away or that you've acquired new assets. The will may still be good, but it's worth getting it checked out to make sure it still does what you want it to do.
Okay. Now, just a technical question here. Let's suppose I have something held jointly with my wife. Do I need to specify that she gets this, or it's already legally set up that she's going to get it if I pass on, or when I pass on?
It depends on the type of asset it is.
Yeah.
For example, usually in North Carolina, if real estate is purchased as husband and wife, it is owned jointly by the husband and wife, and it would pass automatically to the surviving spouse once one spouse has passed away. Same is true with a joint checking account with right of survivorship. But it all depends on how the asset is actually titled. And just because you have a spouse doesn't automatically mean that whatever asset you have will go automatically to the spouse.
Oh, I see. So that ought to be specified too.
It should be specified either in the will, or there's also other types of assets where you can designate beneficiaries. And those would pass outside the will. But by designating a beneficiary ahead of time, you know what's going to happen.
Okay, that seems clear. Let me ask you. Okay, so I've made a will. Who ought to get copies of this will?
It's a good question. It's really personal preference as to who should have copies of that document in their possession. Many folks don't want anybody to know what is actually in their will, which is fair enough. That's their prerogative. However, whatever document is in place, you want to make sure other people know, your loved ones, the folks who are affected by that document, and the folks who are going to be making decisions as a result of what you put in that document. You want to make sure they know those documents exist. Because if you put it all on paper and then put them away somewhere and nobody knows where they are and nobody can access them in the time that they need to be accessed or need to be used, then those documents aren't going to do you any good.
Of course not. Right. Okay, I got you. You mentioned something back a while ago about guardianship. Are you talking about guardianship of, let's say, my children or something? You mentioned about children, but what about me? Suppose I want to put something in the will about what if I get to the point where I'm no longer able to function or make decisions? What about guardianship of me? How do you handle this?
And that goes back to the powers of attorney. Because if you have those powers of attorney in place, more likely than not, you're never going to need to go through that guardianship process.
Okay.
Because those powers of attorney will kick in once you no longer have capacity to make decisions for yourself, and you said ahead of time, if that happens, then I want this person or these people to be the ones making my decisions for me. However, if those documents are not in place, then if something, if an asset needs to be sold or if a healthcare decision needs to be made, then at that point, the only option is to go through the guardianship procedure. And that's a proceeding that involves the court. Someone has to petition to be a guardian for that person, but the first step of that is to ask the court to adjudicate or deem the person incompetent. So it's not a pleasant experience. It certainly serves its purpose because there are certainly times when that's the only option. But if you can avoid that through the powers of attorney, it's a really good thing. But that first stage is the adjudication of incompetence. And then once the court is satisfied that the individual is incompetent, then the court will appoint a guardian.
Okay. Talk about estate planning.
Estate planning is it's a kind of a hot topic right now. Everyone is concerned about their shrinking assets or their portfolios that are no longer portfolios. But estate planning encompasses a number of different tools basically to help make sure that the needs of the individual are going to be met for the course of their life. That can involve making sure assets are in the right area if they're set up properly so that they're going to have the appropriate returns to keep them able to pay their bills and everything like that once they're truly retired. But it also includes long-term care planning. And as everyone now is living longer, long-term care is more and more of an issue. And of course, healthcare costs are continuing to rise. And so there's there's different types of ways to structure assets to be able to cover those long-term care needs. Long-term care insurance is a new, not new, it's a growing, you see more and more folks using long-term care insurance, and it's becoming a little more affordable. But essentially, from the long-term care planning piece of it, there's really only 3 ways to pay for long-term care. One is just straight out of pocket, and that's where that estate planning piece comes in. That's so important to make sure there's enough money set aside or enough return coming in to cover that. The second way is through long-term care insurance. And of course, the third way is through Medicaid. And Medicaid is a need-based service, government service, that will provide nursing or skilled care. But obviously, there's certain requirements that have to be met, including spending down most of your assets in order to qualify for that.
Right.
So if you're not going to fall in that category, it makes that estate planning and that long-term care planning piece that much more important.
Right. That spend down, that would actually be Medicaid, wouldn't it?
Correct.
Yeah. Okay.
Correct.
Okay, I got you.
Yeah, Medicaid, actually, this is, a lot of folks don't know the difference between Medicare and Medicaid. And Medicare is essentially like a health insurance. The Medicaid is covering the skilled care. And so Medicaid is the need-based government benefit, whereas Medicare, most people over a certain age will have some Medicare benefit.
Yeah. I was thinking you undoubtedly get some clients coming into your office to do estate planning or prepare a will where one of them is eager to get it done and the other one is kind of dragged in kicking and screaming. I'm just wondering about situations like this, what it takes to get somebody unwilling to talk about these things to come into the lawyer's office.
Well, and you raise a very typical situation, and not so much between spouses. Usually by the time they get to our office, they're both relatively on board.
Yeah.
They may not be exactly on board with what they need to do, but they know they need to do something.
Right.
And so then once you lay out the information, then usually they both will get on board pretty quickly. The scenario that we see more often is when the children of seniors have gone through something or learned something that they think it's important for their parents to start making a plan. And it's the parents together who come in kicking and screaming or won't come in because they don't, they just don't want to have to deal with those things.
It's a frightening topic for people to deal with, particularly people who are older and to see the inevitable advancing, inexorably.
It is, and it's a delicate subject, and we often spend a lot of time talking with children of seniors as to how to have that conversation, how to kind of break the ground to get into that discussion. And one of the easiest things to say is, and it's absolutely true, is here's the deal. These decisions are going to have to be made at some point. Wouldn't you like to have some input into what those decisions are?
Okay, that sounds good.
The second part of it is, if there's a plan in place, you create more options. It's much easier to, when you're healthy, say, okay, this is what I want, these are my wishes, this is what's going to happen.
Okay.
And you have options. And it may not seem like you have options, but at least you know what's out there, and then you can create options almost. But if you wait and do nothing until crisis mode, then you run out of options. And so you're forced to make decisions based on that particular crisis. And then, you, like I said, you run out of options, and your choices are limited as to what you can do at that point.
Okay.
And usually the combination of those two factors bring people around to start thinking about what they need to do.
Right. The fact that don't you want to make decisions now while you're capable of making them, and don't you want to make them now while there are still options available?
Correct.
Right. Sounds good.
And the third factor that plays into that in some folks' decision is that if you tell them this is going to make things easier for your children because your wishes will be spelled out, that often helps a lot as well.
I would imagine that would. I would imagine. Yeah, it's turbulent enough when a parent dies and people are, besieged with problems with undertakers and funeral services and notifying the family and having to deal with somebody's last wishes and you don't even know what they are. So that would be a very good argument to get someone to talk right now.
And it's hard because that emotional piece is there.
Sure.
When you can sit back from it, yes, a lot of times, a living will, is that a pleasant thing to think about and talk about? No. But if you can think about it sort of not right on top of you, but this is a plan for down the road. This is a plan to make sure things are in place while you're healthy, while you can think, while you can rationalize it. And then you can sort of put it away. You know it's taken care of, and it gives you peace of mind to know things are in order, and you can go about doing what you like to do.
Yeah, absolutely, absolutely. Nothing sort of brought out the importance of having an explicit living will written down as the 2005 case of Terry Schiavo, which became a political football involving the Congress of the United States and the governor of Florida. It was a sad thing. I mean, nobody's a winner in that situation. But again, as I say, it emphasized, the importance of having something explicit written down and physical so everybody could see it.
Absolutely. And it makes my job a whole lot easier.
Right.
Because by having that example and everything that family went through, it's just tremendous to have that example to talk to clients about, because they could say, oh, yeah, I don't want that.
Right. Just mentioned Terry Schiavo, and you've advanced the cause quite a bit.
Exactly. It's because nobody wants their family to have to go through that, and nobody wants to be that individual that everybody's talking, oh, well, what do we do with?
Right, right. Jennefer, you mentioned long-term care. I know this is a little off your area of specialization, but I was just wondering about, you had mentioned that the cost of that had come down somewhat. I guess the alternative, if you need long-term care and you don't have the money, you end up on Medicaid. Is this after a spend down and all those things?
It is true. I usually encourage people to look into the long-term care insurance and see what that option is. That way they can make, again, goes back to that informed decision piece of it. But if they know what the cost is, then they know whether that's a realistic option for them. If it's not, then we go about looking at that estate planning piece or that long-term care planning piece, looking at what their existing assets are, what they would be able to cover for long-term care, paying it out of pocket, and then we look to making sure that they are in a position to sort of transfer smoothly into needing Medicaid.
Okay.
So again, there is still planning involved, and just because somebody says, oh, well, I'm going to be on Medicaid, I won't have a problem, it's still worth having somebody take a look at your assets and making sure that plan is appropriate so that there won't be any gaps in the process.
Absolutely. Absolutely. Right. Okay. I wanted to, by the way, is there anything so far that we haven't touched on that you would like to touch on? Anything we overlooked?
The one thing, just looking back at the Medicaid piece of it, that there is new legislation. It's not so new anymore, but it makes starting in 2010, the look-back period for all types of transfers will be 5 years.
Yes.
And also the estate recovery piece of the Medicaid benefit is becoming more and more in use, or something that the government is looking at, which means that even for a home, for example, that is potentially an exempt asset, the government after death can then come back in to look to the equity in the home to get some recovery for the benefits that they have paid.
Okay.
So it's just, I think, one thing that I always tell clients is, let's take a look at everything. Let's take a look at the big picture, because it's important, even if you're looking at qualifying for Medicaid, that you understand the ramifications that are going to be involved.
Okay. You mentioned a couple of things that our viewers may not be familiar with. You mentioned a look back, a 5-year look back. Could you go into detail about what this is?
Sure. Essentially, anyone who is looking to qualify for Medicaid, and there's some very specifics that I won't get into right here because there's complicated formulas and there's specifics with regard to when the time frame actually kicks in. But generally, there's going to be 5 years that is going to be a 5-year period of time that the government can look into as to what transfers have been made. And so if there are transfers that have been made for less than fair market value, they're going to look to see where that asset went.
In other words, if I, let's say, write a check for $1 million to each of my children, something like that.
Correct. Or if you give your house to your children, something like that, then they will look at that, and there may be penalties assessed if it falls within that period, depending on what the value of that asset is and when that transfer took place.
Okay. And you also mentioned estate recovery. I gather that what you were talking about was that, this is after your death, the government can now look at some of your assets which you might have thought were exempt, like a house or perhaps a car, and they can see if they can maybe recover some of their costs for Medicaid or whatever, from the sale of this asset.
Correct. And basically it would be assets that would not have prevented you from being eligible for Medicaid benefits, but that will be looked at after your death in, maybe repaying some of those benefits.
Okay, I got you. So let me kind of summarize what's important. I guess there's nothing more important from what I've heard from you and what I've learned from you than to have a set of documents in the house, a will, a living will, a power of attorney, a guardianship if necessary, but probably the first thing is a will and a living will and probably a health care power of attorney. Those 3 documents would be absolutely essential.
And the financial power of attorney.
And the financial power of attorney. Okay, those 4. And if you plan on being cremated, maybe that would be a 5th one.
Right, at least have some reference in there somewhere to that.
And have it in a secure binder somewhere, safely locked away in the house where it, can't burn up or likely to be stolen. And make sure that all relevant people know of its existence. And maybe even have a photocopy of the contents. Your children, your executors, if they're not your children, whatever.
And certainly with that summary is absolutely correct, but especially with the powers of attorney, it's very easy to make sure that the folks who you have named to make decisions for you, that they have copies. Because that's just a really good, then they have it in place, they know that it's there. There's also, not everybody knows that the service is in place, but the Secretary of State has a advance directive registry, and they will accept for filing or registering a healthcare power of attorney or a living will, and they will put that on microfilm, and then they'll send back wallet-sized cards so that you could, instead of carrying around a document, you can just carry a wallet-sized card, or you can give that to your agent, and they can carry that around. And if you present that to the hospital or to a physician, they can then, the information on the card will allow them to pull up that registry, and so they'll have access to that document.
Oh, that is very good.
It's a very nice service that they offer, and it's relatively inexpensive. So it's a great service.
Okay, that's good. With the advanced directives in living wills, I was wondering, I've seen some of these before, and they seem to me, when I looked at them, to be fairly vague. And I guess everybody, has their specific fears of things that they don't want done to them. Are they making them more specific, or you can edit them? You can add on to things if you want, I guess.
You certainly can, and that's one of the things that we do. There are obviously certain pieces of the document that have to be there to be effective and be valid under North Carolina law. However, there is always room for special instructions with regard to, whether it's certain types of treatment or length of time of treatment. Anything that any individual has a strong feeling about, you really want to try and get it on paper. And that's our job as attorneys, to try and make sure their wishes are spelled out as accurately as possible to give the folks who are going to be reading that document the best guidance possible.
And before I ever go to your office, or any client does, I guess it would help to have a meeting at home and talk about this openly. What are the things that you're afraid of, that you don't want done to you, and write these things down so that you don't have to come up with this stuff on the spur of the moment in the attorney's office.
And that's very true, because it's helpful to have some time to reflect and some time to think about it. And you might not think of one thing while you're sitting down looking at it the first time, but it might come up after you start thinking about it. And so it's important to have those conversations, and also just not only to have the documents in place like we were talking about, but having those open conversations so your loved ones and your family know what your wishes are. And also, it might give you some insight, too, as to who you might want to serve as those agents under your powers of attorney. Because you may know, based on the conversations that you've had, that one of your children or whoever you're going to name really isn't going to be the right person for a healthcare power of attorney.
Right.
Because they might not, under any circumstance, be able to say, okay, these are what Mom's wishes were. We have to abide by that. They may not be able to, from an emotional standpoint, be able to take that step. And so you want someone who's definitely going to be able to carry out what your wishes are.
Yeah, that sounds very good, Jennefer. Well, we've just about reached the end of our program. Any quick last thoughts about one sentence in length that you can give to our people?
Have a plan. That's it. Have a plan.
Have a plan. That's the most important thing, and don't just daydream about it, but do it. Okay. This has been Aging with Attitude, and our guest this evening has been Jennefer Garrity, an elder law attorney with the firm of Garrity Gossage. I'm Alan Levin, and we're here the second and third Saturday of the month at 8:30 p.m. Be well.